Welcome back. The Wesizwe Party in KwaZulu-Natal says it stands ready to defend and support former President Jacob Zuma's daughter, I Duduzile Zuma-Sambudla, when she appears at the Durban Magistrate Court on Thursday. Zuma-Sambudla is expected to be charged in connection with her alleged involvement in the 2021 July riots. Now, over 350 people died during those riots. The violence broke out following the arrest of former president for violating a constitutional court order to appear before the State Capture Commission of Inquiry.
The 2021 July riots remain one of the country's darkest periods. Businesses and critical infrastructure suffered extensive damage, resulting in the loss of over 50 billion rand to the country's economy. MK Party President Jacob Zuma's daughter, I Duduzile Zuma-Sambudla, has become the latest to be charged in connection with the unrest. During the hearings of the Human Rights Commission into the riots, Zuma-Sambudla's posts on social media were described as celebratory. The MK Party in the province believes her arrest is politically motivated.
It shows you very clear that people just want instability in the black people's lives, particularly women, young women who are future leaders, to suppress them politically, to suppress them in leadership, and also an attack to uMkhonto Wesizwe Party, specifically the people of KwaZulu-Natal. So we are ready for tomorrow as uMkhonto Wesizwe, all commanders, all ground forces, to support our sister, the commander, the member of parliament. Will be out in numbers to make sure that we do what we do best.
Attempts to get a comment from the National Prosecuting Authority were unsuccessful. 65 alleged instigators are expected back in the Durban Magistrate Court in May on charges of conspiracy to commit murder and terrorism. They are accused of instigating violence during the civil unrest and allegedly conspired to kill former Chief Justice Raymond Zondo. Simpiwe Makanya, SABC News, Durban.
All right, let's make sense of this now and speak to legal analyst Nthabiseng Dubazana, who is joining us. Nthabiseng, good evening to you. Thank you so much for your time. Your take on these developments?
Thank you so much for having me. I believe the situation as it stands is a little bit interesting, considering the way in which she was charged and the timing of it, to be quite honest. Because if indeed her utterances on social media were instigating, I believe she ought to have been charged with the 65 people that have already been charged. But with that being said, we understand that it is very likely that she was approached by the Hawks or the SAPS, whoever is holding this particular case, and she most likely would have had an attorney present. Because what usually happens is that when you're going to be charged with the crime, you are either arrested and then taken to the charge office where you're going to sign a warning statement. Alternatively, the investigating officer will then inform you that, listen, there's a case against you and we need you to come to the police station where you can sign a warning statement. With that kind of information and armed with an attorney, she would have probably arrived there and wanted to understand what is the charge in terms of Section 35 of the Constitution. What is the charge, the full details of the charge, what did I do, so that she can be able to sign to the warning statement. With the failure of that being present, it is likely why she wasn't charged then, but only being charged now.
And how much of that will the defense also play, into, especially because when you speak about the timing, I mean, the tweets were there. A lot of people were talking about, the fact that, take her in as well, because the ad tweets, she was, quoting and responding to some of what was taking place, saying, we see you on the ground and all of that. And people were saying, why then don't you take her in? And some of the people there also saying that if you are taking the 65, should she not be part of it? So how much of that will the defense also speak about when they then appear with her tomorrow?
Well, tomorrow it's likely not going to be much of a case in terms of what she did or did not do. It's only a first appearance. So the first appearance is basically confirming that the attorney is confirming their appearance and that a date will be postponed probably to the same date as the other 65 people who have been charged. Mm-hmm. So tomorrow, I don't expect anything much to happen. The only address, perhaps, that the criminal attorney, defense attorney, would say that we hope that the investigations are now complete and that this postponement will then give us the copies of the docket. Armed with the copies of the docket, they can now go consult with their client, peruse all that information, and then come back and say, based on the information that is within your docket, it doesn't seem that you have a prima facie case against my client, and therefore we are making representations to say, withdraw the charges. But tomorrow that will not be canvassed because it's only her first appearance, just to confirm that she'll most likely be added to the 65 already to make it 66. And then in May, perhaps all of this will be dealt with.
And Nthabiseng, you remember when all of this was happening, there was that case as well of a pity evaluator on X as well. And a lot of people were talking about that. And that now we haven't heard more from that?
I think that what could have happened there is that maybe as the matter proceeded, one of two things actually could have happened. One, it could have been a situation where the matter kept getting postponed and with no real results coming from the state. And the defense attorney most likely would have made an application in terms of Section 342, capital letter A of the Criminal Procedure Act, which is the undue delay of criminal proceedings. And then with that, the court probably struck the matter off the roll, and it may come back again once the state has sorted its house. Alternatively, the docket was given to the attorney, and then perusing it, there's not enough evidence to prosecute. And then they made representations, and then the state had no other choice but to withdraw the charges.
So, Nthabiseng, there are some reports that are suggesting that this case against her was opened by a private person who laid a criminal, complaint against her. So, be that as it may, can we see her not being joined, as you've said maybe earlier on, that possibly she may be joined with the other 65? Can we see a separate case, possibly? Is that a possibility at all?
It is very likely, because in order for that to happen, remember Section 7, I believe it is, of the CPA permits a private individual to prosecute another. But you need to have a certificate of nolle prosequi from the state that confirms that they are not proceeding with this matter. In that particular instance, then it will be a separate criminal matter that does not adjoin them. However, the catch is this: the information that they are going to need in the private prosecution stems from the one that includes the other 65. Because how else are they going to get the information? How else are they going to get docket information, witness information, everything that was there? And with that, it won't make sense to join them, because now they would have to probably request copies from the state in order to bring those copies into this particular situation, which doesn't make any sense. What makes more sense is let them be joined, let them appear as one, let the court decide whether there's sufficient let the court decide if there's sufficient evidence to prosecute.
So when you then look at, because we're seeing that she may be charged under the Terrorism Act, let's speak about that aspect as well, and just how much of, the state would need to rely upon when it comes to evidence, because some are saying that maybe the tweets alone may not be enough.
Yes, it's very likely that the tweets alone may not be enough. We need forensic evidence, one, to confirm that it was from her page. That's the first thing. So now we are looking at 212 statements, wherein a forensic analyst that deals with electronic messaging or electronic media, whatever the case may be, who can confirm that the tweets come from her page. Because in criminal law, what we call real evidence has to be confirmed that it wasn't doctored in any way. That's the first thing. And now with that, we also have to request, in terms of Section 205 of the Criminal Procedure Act, to go into her personal accounts, because the state doesn't have a real right to go into somebody's account without it being a court order. So the 205 application will have to be done. So there's a long road ahead, which we hope the state has covered from the date that they arrested the other 65 up until now. Because if they haven't, and this matter keeps getting postponed for further investigations, we will see the matter being struck off the roll because the state is delaying, and then everybody is free again, and then we may wait another 2 years before it comes back on the court roll.
And as you say, lots of questions will then be asked even about, why now? Why then did you not charge her, to begin with the other 65? And it'll be interesting to hear what comes out from the court as the matter, unfolds. Thank you so much, Nthabiseng. Let's see what happens tomorrow then. Appreciate your time. That was legal analyst Nthabiseng Dubazana.